what really struck us and why we went all in on this whole blockchain movement is we just realized there's a fundamental problem in the world.
In the legal battle between the U.S. Securities and Exchange Commission and Ripple, who do you think will emerge victorious? It is no secret that experts have varying opinions about the conclusion of the case, with some supporting Ripple's stance. So what can we expect about the case based on recent developments? A few days ago, rumors circulated that Ripple Labs Inc., the US-based technology company that builds XRP infrastructure, may soon settle with the SEC. Notably, a few days before this rumor spread like wildfire, Judge Annalisa Torres reportedly ordered the regulating agency to unseal former SEC functionary William Hinman's documents in the case. The situation received many comments from prominent lawyers in the crypto sphere. Fred Rispoli said that the summary judgment ruling seems to be nearing its completion, saying the decision to unseal Hinman's emails is noteworthy. Jeremy Hogan agreed with Rispoli, noting that the order's phrasing might suggest that a significant portion of the order on summary judgment may already be drafted. SEC enforcement specialist Mark Fagel has concurred with Rispoli's assessment, considering it a well-reasoned evaluation of the situation. What was that about? For context, Judge Annalisa Torres of the Southern District of New York denied the SEC's request to seal documents pertaining to a speech by Bill Hinman, the director of the agency's corporate finance division. The speech in question, which outlines why Hinman does not consider Bitcoin and Ether as securities, has previously faced attempts to seal it by the SEC. In 2022, Sarah Netburn, the judge presiding over the case at the time, denied the SEC's request 3 separate times. According to Judge Netburn, the reasons for these requests were conflicting and not in the law's best interests. She said, "The SEC is adopting its litigation to further its desired goal, and not out of a faithful allegiance to the law." The SEC first tried to stop Hinman's speech from being used by declaring that it reflected Hinman's personal opinion, not that of the securities regulator. After this approach resulted in a denial of the request, the SEC claimed that the speech was related to his internal duties and thus should be shielded from public view. However, this request was turned down too. What are the Hinman documents actually about, and why is the SEC taking pains to have it sealed? The Hinman documents refer to a 2018 speech given by former SEC Director William Hinman, and documents associated with writing it. In the speech, Hinman said that Ether should not be considered a security given its decentralized nature, stating, "Putting aside the fundraising that accompanied the creation of Ether, based on my understanding of the present state of Ether, the Ethereum network, and its decentralized structure, current offers and sales of Ether are not securities transactions." This was considered a landmark speech, as it signaled to the crypto industry that it could be possible for cryptocurrencies to transition from securities when they are first created to commodities once they are sufficiently decentralized. This could have an impact on Ripple's fair notice defense, which comes into play if Judge Annalisa Torres finds that Ripple did indeed sell unregistered securities. Ripple requested the documents in discovery, and the request was granted in the last half of 2022. While the documents could be used as part of Ripple's defense, the SEC has attempted to keep them sealed on multiple occasions, arguing that they are irrelevant to the court's summary judgment decision. In light of this, following their prior failed attempts to shield the documents, the SEC filed yet another request in the same vein, which was denied by Judge Torres just a few days ago. As Judge Netburn found in her order dated January 13, 2022, the Hinman speech documents are not protected by the deliberative process privilege because they do not relate to an agency position, decision, or policy. Therefore, sealing these documents would not be related to preserving openness and candor within the agency, said Judge Torres. According to the judge, the document should be accessible on the common law practice of public access to judicial documents alone, regardless of whether they are admissible in court or not. Documents are considered judicial documents if they are relevant to the performance of the judicial function and useful in the judicial process. The relevance of a specific document does not depend on which way the court ultimately rules or whether the document ultimately in fact influences the court's decision, said Judge Torres. Rather, what is important is whether a document would reasonably have the tendency to influence a district court's ruling on a motion. She added, "The news was, as can be expected, celebrated by Ripple CEO Brad Garlinghouse, who praised the judge for her commitment to transparency and stated that the documents will be released publicly as soon as Ripple's lawyers are allowed to do so." In a recent tweet, Garlinghouse shared, "Another win for transparency. unredacted Hinman emails to be publicly available soon. Stay tuned as the lawyers work through the mechanics to make that happen. Yes, that might be a reason for a cheer, but don't pop the champagne just yet. You should keep in mind that although Ripple has crossed yet another hurdle, it's important to note that this case is nowhere near its end and has been dragging on for years. But don't get me wrong, you and I both are more than ready to see this case come to a conclusion. Meanwhile, Ripple too tried to redact several documents of its own, including contractual agreements, financial information, and other types of information. The judge is allowing many of these proposed redactions, including redactions tied to the company's financial statements and certain business information, to go through, saying she agreed with Ripple's assertion that they're targeted and specific. However, the judge did rule that other proposed redactions are overbroad, including several proposals tied to XRP. That said, what does the latest ruling mean for the case? While it's still too early to tell what the ultimate outcome of the case will be, the court also denied certain motions to seal from Ripple, as earlier mentioned, which included references linking Ripple's revenues with XRP sales and the amount of compensation offered to trade platforms, among others. In a series of tweets, John Deaton, known to be a pro-XRP lawyer, said that since the judge's decision regarding what can or cannot be sealed, like the Hinman emails, many people are discussing a split decision where Ripple gets tagged for early XRP sales, but ODL and secondary market sales are found to be non-securities. Deaton added that if that happens and the judge agrees with Ripple, the jury must then decide whether those early sales should be excused because Ripple lacked fair notice and XRP sales were effectively illegal, unregistered. It can only be described as a total victory for Ripple. However, he also shared his thought that the chances of Ripple getting a complete victory are much slimmer now. He said in the same Twitter thread, "I think the chances of Ripple getting a complete victory are much slimmer after reading this than I felt before. I still don't think the SEC is getting a complete victory either." Deaton theorized that the courts could decide to fine Ripple for its early sales of XRP related to the initial coin offering and other transactions aimed at boosting the network, but that secondary sales of XRP and the coin itself are not securities. Deaton's thought on the subject were given further credibility when former SEC securities lawyer Mark Fagel added his voice to the Twitter space, saying that he generally agreed with everything that had been said, but that the SEC suit was worded in a way that focused on the tokens issued by Ripple and not secondary market transactions. Fagel added that he thought Torres would be overstepping to make a ruling on secondary sales, but he believed they were helpful in the SEC's case, as they illustrated how a secondary market would not have been created without Ripple issuing securities while promoting the network. All that said, when can we actually expect the verdict of this case? In a recent Twitter thread, prominent pro-crypto lawyer Fred Rispoli suggested that the summary judgment ruling is already written and could be issued any day now, while also agreeing that a split decision was the most likely. Rispoli said in the tweet, "Very hot take. The SJ ruling is obviously written, maybe completely finished, maybe some final touches left. Been saying any day now for a while, but it's really any day now." Deaton, on the other hand, noted during the Twitter space that he believes Judge Torres knows how she will rule, but added that guessing how much is written in its final form would be pure speculation. The pro-XRP lawyer also agreed that the decision could come down at any time, but he added that it could take another month or longer. What do you think? Do you have any guess as to when we can finally breathe? Whether a relieved sigh or a sigh of exasperation, depending on the judge's ruling? Stay tuned for updates, so make sure to hit the subscribe button to be updated.